really positive and strong relationship between us community elders and the Centre for Law and Justice. And we've seen kind of real world positive results from the students that have been through the program that you guys are in now. And we're very proud to be part of, what's going on at CSU. So as mentioned by the other elders in the room, we're coming to you from beautiful Wiradjuri country, unceded sovereign Wiradjuri country, and we are custodians. We take our custodianship very seriously. And, we take your cultural safety very seriously as well. And so we'll just talk a little bit about cultural safety before we get going. We'll be sort of coming and going today, but with a definite focus and an invitation to you all to come to the Yalbalinya Yarning Circle this afternoon. We'll be listening into as many of the guest speakers as we possibly can, but obviously there's, you could hear that there were kids in the background and there's things going on. So we'll probably duck in and out. So don't be too worried if you see us go off the screen and come back and whatever. But we'll be as present as possible for everyone during the day. So cultural safety, we've got a pretty clear definition that you hopefully can see on your screen there of what that is and what that means. Cultural safety seems to be a bit of a buzzword these days in the tertiary environment, also in the corporate environment. We've been taking cultural safety seriously for a long, long time now, before it was sort of a buzz thing. And it's a really simple definition. You can see it there. It's an environment which is spiritually, socially, and emotionally safe, as well as physically safe. There's no assault, challenge, or denial of your identity, whatever that is. It's about shared respect, shared meaning, shared knowledge, and shared experience of learning together with dignity and truly listening. And another part that we like to add to that is this idea of conversation rather than being spoken at. So during the day, you'll be given the opportunity to ask questions, to engage, to bring your point of view. So make sure you take the opportunity to do that. Use that opportunity to your advantage, because things like this don't happen every day. The people that are in the room today that are going to be presenting, this sort of gathering doesn't happen all the time. So make the most of that. And another part of our cultural safety message to you is a Wiradjuri concept, and it's a beautiful concept. It's Yinjamal Jurai Yalbalinya Mawang, and it means two-way respectful learning together. And that's the idea that, the presenters and ourselves as elders, we're not just going to talk at you today. We want you to interact with us. We want to learn from you as well. So make the most of the opportunity today. We've got some fantastic guest speakers. We're really looking forward to seeing how the day plays out. And if there's any questions as we go along, while the other guest speakers are doing their thing, the Centre for Law and Justice staff will handle those questions and how those questions can be asked. And then when you're in our session, you just chuck them in the chat box and we'll get to all the questions, and just make the most of the opportunity in this culturally safe environment to ask the hard questions, to ask the difficult questions, to ask the uncomfortable questions. You've got that opportunity in front of you right now. So please make the most of it. Mandangu, everyone. Thank you. Thanks, Mark.
Yeah, Matangu to you, Yana, and to Wirraby and to Dinawan. Thank you for starting us off in that fashion. We're very excited to have this first session focusing on the voice referendum. Hot topic in the media, and it will continue to be. And we're just so thankful to have Bridget Cama with us today. I think I might have mispronounced your surname, Bridget. I'm sorry. Is it Cama?
It's pronounced Dharma.
Dharma, there you go. So thank you very much for being here today. Wiradjuri connections and other connections explained in Bridget's bio. Bridget is a law graduate from University of New South Wales, graduated in 2019 with a Bachelor of Laws and Arts, majoring in Indigenous Studies and a distinction and a minor in politics as well. After work as a paralegal, but other work for Gilbert and Tobin and other secondments during her degree, and other work into the pro bono team at Gilbert and Tobin. Bridget's been working with University of New South Wales colleagues and others in the Uluru Dialogue, has started up the youth version of the Uluru Dialogue, and just really well placed to give us an information session and to answer some of your questions about the law and the issues behind the voice referendum and the Uluru Statement from the Heart and its connection to the voice referendum. So we're just so excited to have you here today. Thank you very much, Bridget. Just checking in again, you are happy for us to continue to record this session, were you?
Yeah, that's fine.
Yeah, okay, so I'll keep that running. And over to you, big thank you.
Thanks, Mark. Before I begin today, I'd like to acknowledge country. I'm on Wiradjuri country today, and also pay my respects to the elders that are on the call today, elders in residence at CSU, Dinawa, Nyana, and Wirraby. And particularly want to acknowledge all of the advocacy and fight that you've done for Wiradjuri people to maintain significant cultural sites, protect country, so that us young ones have that in our future as well. As Mark said, I'm part of the Uluru Dialogue team at UNSW. I work under Professor Megan Davis and Auntie Pat Anderson, who are the co-chairs of the Uluru Dialogue. So I'll just share some slides now. The purpose of today is for you to come out more informed about the Uluru Statement from the Heart, the voice proposal, and the upcoming referendum. Give me a second, I'll just get this up. Okay. Can everybody see those slides? Great. So firstly, I want to talk through the Uluru Statement from the Heart, the journey that led to the issuing of that in 2017, and the 3 key reforms that it calls for: voice, treaty, and truth. Then I'll move to the voice referendum and what's happening now, particularly around the question, the proposed amendment, the processes around a referendum and constitutional reform. And then I'll turn to some resources that you might like to look at if you want to learn more about the voice, the Uluru Statement, and keep up to date with what's happening. And happy to take any questions. I can take those throughout the presentation where they're kind of relevant to what I'm talking to at that particular point, or I'm happy to take them at the end as well, whatever works best, whoever's moderating that. So the Uluru Statement from the Heart, I really want to make sure that people understand that the voice proposal doesn't actually come from Anthony Albanese or the ALP. The Uluru Statement calls for a constitutionally enshrined First Nations voice to Parliament and a Makarrata Commission to supervise agreement making and treaty making processes and truth-telling processes. The Uluru Statement from the Heart was issued to the Australian people from First Nations delegates to the Referendum Council's Constitutional Convention, which was held at Uluru in 2017. And it sets out these key reforms of voice and Makarrata. It is sequenced as voice, treaty, and truth, not necessarily because the voice is more important than treaty or truth-telling, but because the voice will allow us to have structural, substantial reform that will give us some political power that allows us to have a relationship with the Parliament, with the executive government, which we currently don't have. All of us in our communities understand the issues that we face on the ground. And when those issues affect us, we have to advocate for ourselves. We have to trek to Canberra, we have to explain ourselves, we have to advocate for the issues that we're wanting to fix, or the solutions that we have that we know that work. We have to go to Canberra to advocate for that stuff. The delegates to the regional dialogue said, well, we want that to be a standard process where we get to talk to the Parliament and the executive, and they have to talk to us about the issues that affect us. So that is the first part of the voice to Parliament. And of course, treaty is a huge part of what our mob want, and has been for decades. We've never had that treaty process in Australia. We're one of the only countries in the entire world that's been colonized that doesn't have a treaty with its First Peoples. I'm sure I'm not telling you anything new, but this puts us in a unique position as First Nations peoples in Australia because we didn't have that treaty initially, or treaty processes initially. So now we're looking towards how do we work towards treaty and truth telling, which will have positive benefits for our people. We know that our mob have called for treaty for decades now, but there's never been that political will to sit down as equals at the table to negotiate a treaty process or to negotiate a treaty. So it was envisioned that the voice would have the ability to speak directly to Parliament and the executive. And I'll talk a little bit about that a bit later. And I'm sure there'll be questions around the executive government part of the amendment, as well as the possibility in the future to talk to state and territory governments where they request advice or representations from the voice itself. So this is basically what the Uluru Statement calls for, but I just want to take a little bit of a step back to understand how we actually got to the point of the Uluru Statement itself. Throughout our shared history, there have been consistent calls from First Nations peoples for us to have a say over the issues that affect us, to have representation in the decision-making processes that are made that affect our lives. We've called for self-determination, treaty, and for the truth to be told about our First Nations history and our shared history. So it's important to understand that the Uluru Statement and the reforms it calls for were not just something developed in the regional dialogue process. There's a whole history of Black advocacy in this country that has led to the culmination of voice, treaty, and truth. And this came out through the regional dialogues. So the work on recognition of First Nations peoples in the Constitution has been going on for over a decade now. It really started in 2010 when Julia Gillard kind of kicked off the process with the expert panel on constitutional recognition. But since then, we've seen no fewer than 7 processes and 10 reports attempting to deal with recognition of First Nations peoples in the Australian Constitution. So in 2011, the Gillard government established the expert panel on recognition of Aboriginal and Torres Strait Islander peoples in the Constitution, which handed down its report in 2012. In 2013, Parliament passed a Recognition Act and established a Joint Select Committee on constitutional recognition of Aboriginal and Torres Strait Islander peoples. In 2014, the interim report of that Joint Select Committee was handed down, followed by the final report of the Active Recognition Review panel. And during all of these processes, First Nations peoples themselves weren't actually asked what constitutional recognition meant to them. So it wasn't until the 2015 final report of the Joint Select Committee was handed down that Indigenous leaders met together. There was about 40 of them. And they said, this is enough. We haven't actually had a say in any of these processes. We won't accept symbolic recognition because it won't actually make any difference to the lives of our peoples on the ground. And on the 6th of July 2015, they together, there was about 40 Indigenous leaders, issued the Kirribilli Statement after meeting with the Prime Minister and the opposition leader. And they asked for a new process of consultation with Indigenous communities. So in that Kirribilli Statement, and I would encourage you all to read it if you haven't, the leaders declared that they wouldn't support a symbolic referendum or constitutional reform, and said that any reform must include substantive changes to the Australian Constitution. It must lay down the foundation for the fair treatment of Aboriginal and Torres Strait Islander peoples into the future. A minimalist approach that provides preambular recognition, removes Section 25, and moderates the racist power, Section 51, does not go far enough and would not be acceptable to Aboriginal and Torres Strait Islander peoples. So this then led to the Prime Minister Malcolm Turnbull at the time and opposition leader Bill Shorten to establish the Referendum Council. The Referendum Council was made up of both Indigenous and non-Indigenous people, but it was the First Nations members that designed the consultation model of the regional dialogues, which I've talked a little bit about. People might be aware of them, but I'll talk a little bit about in a minute about the details of what those regional dialogues really were. And that it was those regional dialogues that led to the process that delivered the Uluru Statement from the Heart in May 2017. So there's all of this kind of politics that's been involved in this process in constitutional recognition from the very beginning. It wasn't until 2015 that we saw the Referendum Council come in and can start to bring in a process where community were consulted. But following that, again, the Prime Minister Malcolm Turnbull rejected the statement, rejected what the Uluru Statement called for, voice, treaty and truth. And then we've kind of gone on a journey over the years through a Liberal government with a coalition, trying to get them to accept the statement first, and then embark on a constitutionally enshrined First Nations voice to Parliament. But there was never appetite there for it. So we continued to advocate for it through the Uluru Dialogue because of the mandate. And it wasn't until the most recent federal election, when Prime Minister Anthony Albanese was elected, that we finally had a commitment to the Uluru Statement to be implemented in full. So that's a commitment to voice, treaty and truth. And that was a big moment, I think, for all Australians. For me, it's obviously personal. So it was a big moment for me and my team to realise that this was actually coming to fruition, that we actually are now going to referendum on the voice. But the work, of course, doesn't stop there. There's a lot more processes, a lot more scrutiny around the wording. But the goal of the Uluru Dialogue is to make sure that the voice is implemented in the way that is consistent with the Uluru Statement from the Heart and what the regional delegates, the First Nations delegates to the regional dialogues, envision the voice to be. So we don't want a weak reform. So the work continues. So going back to the regional dialogues, and like I said, I'm not sure how across the dialogue process all of you are, but I think it's important to note where this actually comes from. So the Referendum Council was established, and then the First Nations members developed the consultation model of the regional dialogues. So they were people like Pat Anderson, Professor Megan Davis, Noel Pearson, Galare Yunupingu, rest in strength. It was them who designed this consultation model, and they designed it over about 2 years. So there was a lot of thought that went into this process. It wasn't perfect by any means, and I don't want to put it out there as that. It consulted over 1,200 First Nations peoples. Not everybody was consulted in this process, but it was really important that each of the regional dialogues captured the voices of people on the ground in those regions. At each of the regional dialogues, the Referendum Council worked with local Aboriginal and Torres Strait Islander authority bodies, and it was them who actually kind of, ran the whole logistical side of things. They were the ones who worked with the locals and regional peoples to send out the invites, get everybody there, kind of host each dialogue. And it was up to Professor Megan Davis and Auntie Pat as co-chairs to turn up and provide the information to people for them to then discuss what kind of meaningful constitutional reform they wanted. At each of the regional dialogues, there were approximately 100 people who attended, and they were made up of 60% traditional owners or people who had cultural authority and could speak for country, 20% for people who worked in or access service providers that were community controlled service providers who were dealing or who do deal with the issues that our mob face on the ground in their communities, and 20% for people who didn't necessarily fall into the other two categories, So, you know, people living off country, stolen gen, young people, or people who didn't necessarily have elder status or cultural authority, but were, you know, notable leaders in their community or who held influence. And this was up to the regions to decide who were the people to attend the dialogues themselves. Like I said, not every First Nations person in this country was consulted. It is the largest and most robust consultation that's ever happened with First Nations peoples in our shared history. And it's the first time that First Nations people have been consulted over the Constitution. We were deliberately left out of the constitutional conventions leading up to the founding constitution that federated our country, as well as women. But you know, women's issues have moved on, where First Nations peoples we're still stuck there. The 1967 referendum was the most successful referendum in our shared history, and it was, of course, to include First Nations peoples in the Constitution so that they could have the laws at a Commonwealth level be made about them. Before that, it was up to the states, and to be included basically as citizens in our own country. So we haven't moved on past that, and a lot of that discussion happened at the dialogues. It wasn't an easy process. People came in and they were sick of being consulted and nothing happening after they've spent, you know, all of their time, energy, expertise telling governments or participating in consultations by government about what they want for their community, and then nothing happening. They were tired of that happening. There was a huge emphasis on truth telling and why it's so important that our country and its people know the truth about our history. So that's where all of that comes from. It comes through the discussion that was actually had through the regional dialogue process itself. These are some photos from some of the regional dialogues and the Constitutional Convention itself. The one down in the bottom, in the middle, is Ross River, which was the most remote consultation that happened, and it had to be translated into several local languages. But just to give you an idea of what these dialogues actually involved, each dialogue was held over 2.5 days, beginning at lunchtime on day 1 and ending at lunchtime on day 3. The agenda was structured, and it involved intensive civics education on the Australian legal and political system, and a history of Aboriginal and Torres Strait Islander advocacy for structural, legal and political reform throughout our history. The remainder of the first morning then included discussion of the word recognition, because prior to the dialogues, recognition was pretty much equated with symbolic recognition. And we know that First Nations people absolutely do not want symbolic recognition. If we're going to go down the path of constitutional recognition, we want something that's strong, that's substantial, and that actually changes the way in which the government and the parliament have a relationship with First Nations peoples and what we have to say. So that part was really important, because we'd seen things like the Recognise campaign come through when we were being, you know, the campaign was advocating for symbolic recognition with no supportive mob behind it, which is, it was there to recognise us, yet there was not our support behind it. So we'd gone through that process, and people in the regional dialogues had lived through those processes and wanted to really know, well, what can recognition in the Constitution actually achieve for us? And it's actually a spectrum. It can be symbolic recognition, or it can be substantial structural reform. Delegates to the regional dialogue said, well, we have to go for the structural, strong reform on this end of the spectrum. But throughout that process, they discussed various options of constitutional recognitions and legal frameworks, looked at comparative international models, and the 6 principal reform options that were discussed were a statement of acknowledgement, so symbolic recognition, within or outside the Constitution, amendment or replacement of the racist power, repeal of Section 25, constitutional prohibition of racial discrimination, agreement making, and Indigenous voice to Parliament. So they were all of the things that were discussed at the dialogues. You know, they all of the minutes of each regional dialogue were taken down, and at the Constitutional Convention, where 7 delegates from each of the regional dialogues were nominated to attend, their role was to state what actually was discussed at their regional dialogue. And there had to be a vote on what the preferred form of recognition would be, and the voice was received overwhelming consensus. In some places, treaty placed number 1, and in some places, treaty placed last, because there's an exhaustion in some places through native title processes that they weren't even looking at treaty processes at the moment. Like I said, the majority voted in favour of a voice to Parliament. At that Constitutional Convention, there were approximately 250 delegates. Out of those 250, approximately 7 walked out of the Constitutional Convention for various reasons. I can't cover all of them, but from my understanding, it was because, one, they didn't agree with being recognised in the Constitution, full stop. 2, concerns around sovereignty, which I can talk to in a minute about whether that is a legal concern to us or not. And then there were various other reasons, that they didn't agree with the way that the regional dialogues and the Constitutional Convention were being conducted, and things like that. So there were approximately 7 that walked out, but majority supported this. And I think that just goes to show that this process actually captured everyone's voices. It wasn't selective, it wasn't handpicked. It was up to the community to invite who they thought would produce that robust discussion and challenge ideas and challenge those discussions to be had. And I think the fact that 7 people didn't agree to it actually shows that it was a democratic process that included everybody's voices. And 100% respect that they have their views as well, and that all First Nations people should have that ability to have their own views. We're just like everybody else. We don't all think the same. We don't all have the same lived experiences, same politics, ideologies. We are diverse in our peoples, and yeah, we're just like everybody else. We're not all going to agree all the time. But the important thing is that these people actually committed to sitting down and talking it through. So the reason that the voice was so popular is because people had just gone through the Indigenous advancement strategy. People knew that there is that insecurity of Indigenous people's status in the machinery of government, that every time it comes to laws and policies, we might get a win, and then the political, 3-4 year cycle comes back in and we have to start all over again. The Indigenous advancement strategy particularly had a big effect because we had local Aboriginal community controlled organisations running really effective programs, services, because they knew what their people needed in community. And then you had the Indigenous advancement strategy come in, wipe all of that funding out, give it to non-Indigenous organisations to provide those services, resulting in poorer outcomes, not culturally safe services, all of that stuff, which resulted in, lower outcomes or worse outcomes for people in communities. And so that was very topical at the regional dialogues. And people know in community, in the most regional communities, they understand that everything that affects their lives, laws, policies that are imposed on them, all those decisions are made in Canberra. And so there was a lot of sentiment around feeling powerlessness and voicelessness in their own country about the issues that affect them, despite knowing what works for them on the ground, despite having extensive lived experience and expertise knowledge about firstly the issues, and then secondly the solutions, but that is constantly silenced. That is the conversations that came out of the regional dialogues. And those delegates saw the voice as an opportunity to change that, to standardize a process where the parliament and the executive, every time a law, policy or decision is made about their lives, that they have to be consulted through their representatives who they elect to the voice. I feel like I'm talking a lot, and we talked about not talking at people, but I hope if anyone has any questions, just jump in. So following the issuing of the statement, the Uluru Dialogue was set up, which is who I work for. You can see up in the corner, there's Auntie Pat Anderson and Professor Megan Davis. Down the bottom, we have our youth dialogue, and then Alira Davis and I are over there on the side. So the dialogue was set up to keep progressing the reforms that the Uluru Statement called for, because it was obviously rejected by Prime Minister Turnbull. And the people that worked on this and the regional delegates said, you know, we can't just accept no, we have to keep moving forward. And that's what they did. And yeah, now we're going to referendum. So our four key parts of work are consultation and Indigenous support. So we continue to do that work. Obviously now we're going to referendum, so it's ramping up even more. The legal work and reform, that's mostly led by Professor Davis, and she has been a part of the constitutional expert group who have been advising the government, as well as the referendum working group, who were advising the government on how to progress towards a successful referendum. Political support is obviously really important, but at the end of the day, we want this to be led by people, not politicians. And lastly, the education campaign. So that's stuff like I'm doing today. And that's a key part of the Uluru Youth Dialogue work. We go to, you know, community events and hold information stalls and just talk to everyday Australians about what this is, so that they can make an informed decision when it comes time to voting at the referendum. How am I going for time? All right. So this is probably the most interesting part in terms of the topic that we're talking about today, the legal matter behind the news, the voice referendum and what's happening right now. So, like I've said, the ALP have committed in full to the Uluru Statement from the Heart to implementing voice, treaty and truth. And as soon as Albanese was elected, he kicked off working towards a referendum on the voice by setting up 3 advisory groups. I'll talk to you about the proposed referendum question, the proposed constitutional amendment, and the design principles, and then we might nerd out on the referendum process. So this is Albanese announcing his commitment in May 2022, and then we headed straight into setting up the referendum advisory groups. So there were 3 set up. The referendum engagement group, which brought together key leaders working on the ground, and that group provides advice on engaging and building support in communities for the referendum. The middle one is the referendum working group, which was really the key group in this process of getting to the point of having a question and a proposed amendment. The referendum working group was made up of Aboriginal and Torres Strait Islander representatives from across the country, including land councils, local governments, and community-controlled organisations. And their whole, I guess, purpose was to provide advice to the government about how to work towards a successful referendum. And from the Uluru Dialogue's perspective, it was to ensure that the proposed amendment was in line with what was called for by the Uluru Statement and the regional dialogues. And that was for a strong amendment that included both the advice or representations to Parliament and the executive, because we know that it is the executive who makes so many decisions. through, delegated legislation. Their ministers make a lot of decisions that affect our lives. It is the executive government who implement policies that are rolled out and imposed on our communities that don't necessarily have to go through Parliament. So it's really important that the executive government is included in the amendment. And then the legal expert group, it advised on legal issues to the referendum working group and engagement group. And it was made up of Indigenous and non-Indigenous constitutional experts and legal professionals. So we now have the proposed question and amendment, and that was announced on the 23rd of March, so not that long ago. The Prime Minister announced it alongside the referendum working group members. I'm not sure if any of you caught that particular press conference, but I would encourage you to go have a look at that as well. But in terms of the legalities of it, the question is pretty simple, and that's intentional so that Australians actually know what they're voting for or against when they go to vote at referendum on the voice. So it basically says, there will be a proposed law to alter the Constitution to firstly recognise the First Peoples of Australia, and doing this by establishing a voice and then asking the voter, do you approve of this proposed alteration? The proposed amendment, which is what we were all kind of sitting on waiting for to come out, it's a little bit different to what Albanese released at Cama last year, and is also different from the Indigenous Law Centre's draft proposal as well, but it brings elements of both of them together. And if anyone's interested, I would encourage you to jump on the Indigenous Law Centre's page. It's IndigConLaw is the blog, and it includes all the draft papers, proposed drafts of the question and the amendment, and it has discussion points around everything from the name of the voice to whether executive government should be included. And there's some really technical points, but as legal students, you're probably interested in those and how the process kind of discussed all of those things and came to the conclusion of this proposed amendment that has been put to Parliament not that long ago. So you can see that there's three key components to the proposed amendment. The first opening line makes it clear that this is about recognising Aboriginal and Torres Strait Islander peoples as the First Peoples of Australia. The first clause is about establishing the body. There shall be a body to be called the Aboriginal and Torres Strait Islander voice. The second one, it captures the core function of the voice, and it's important that this is in the Constitution so that it can't be taken away and that the voice will always have this core function. And that is to make representations to the Parliament and the executive government of the Commonwealth on matters that relate to Aboriginal and Torres Strait Islander peoples. I'll just make a point there around representations. Representations is more than advice. Representations includes allowing the voice to be able to table reports, to be able to table, research that's been done by the voice, supporting the advice, as well as, statements from people on the ground. Anything that is beneficial to supporting a particular position or guiding the Parliament or the executive in a particular direction that aligns with what people on the ground want or are saying. And then the third clause is allowing, it's an enabling clause. It allows the Parliament to have power to make the laws with respect to matters relating to the composition, functions, powers, and procedures of the voice. So this is important because it allows the Parliament to have the ability to continue to have parliamentary sovereignty over the way that the voice works. It also allows the voice to be flexible over time, which was talked about in the dialogues, to be relevant and to allow First Nations peoples to use the voice in a way that they require at that particular time. So, in 50, 60 years' time, the voice might look different to what we need, now. And that will continue to happen over time. And once the voice is established, the voice will actually also be able to make representations on that particular legislation about what the voice should be in terms of its composition, functions, powers, and procedures. So there's a lot of conversation going around, where's the detail? We don't know what we'll be voting for. The Referendum Council, with the support of the government, released 8 design principles of the voice. And these were developed by the First Nations members of the Referendum Working Group, alongside the Indigenous Law Centre and previous work done by Professor Megan Davis, Marcia Langton, and others. So I'll just go through those now, but you can find them on the government website, the NIAA website, the ulurustatement.org website, as well as other various places. But they're really helpful to understand what the voice will actually look like. So firstly, the voice will give independent advice to the Parliament and government. So it's able to make representations to both the Parliament and the executive government on matters relating to our people. The voice will be able to be proactive. So it doesn't have to wait until the Parliament or the executive comes to them and say, we want you to provide representations on this particular matter. The voice will be able to pursue issues that affect Aboriginal and Torres Strait Islander peoples, that our people are saying, we need to address this right now. We have had so many reports, so many recommendations, royal commissions that have not been implemented. The voice will actually be able to proactively pursue those pieces of legislation that those recommendations relate to, and say, well, we make a representation on this particular piece of legislation. It's really important because it affects our people in these ways, and this is what changes or advice or representations we make to improve the legislation to result in better outcomes for our people. It will also be able to respond to requests for representations from the Parliament and the executive. That's a pretty obvious one. It will be independent and have its own resources, which I think is so important to understand, that it will be the representatives elected by a mob who will have their own lived experiences, who will be required to consult with the people or the constituents that elected them and that they represent, but they will also have a support team behind them. So people who will be able to do the research and develop all of those things to help inform best practice and best policy and law. And it's really important that representations are made by the voice early in the development of proposed laws and policies. Obviously, if we're there right from the beginning, having a say right throughout the process, you're going to end up with better laws and policies. B, the voice will be chosen by Aboriginal and Torres Strait Islander peoples based on the wishes of local communities. And this is in line with, international law, the UN Declaration on Indigenous Peoples' Rights, the fact that Aboriginal people themselves will be able to elect who represents them on the voice. And not only that, is that they'll be able to elect them in the way that they choose. So that might be, traditional democratic processes, that might be cultural authority or traditional cultural law delegation. It might be a mixture of both. And that comes back down to self-determination. It's really important that the communities themselves get to choose or elect the people that represent them in the ways that are best suited or chosen by them. This one was, I think, really important because culturally, we've always, had men's, women's business, had our own roles. But throughout colonisation, we haven't necessarily had equal representation in certain spaces. We've seen, governments only listen to voices of particular groups, particular people, particular genders. We are obviously a gerontocracy, so our cultural authority is with our elders. But we think that youth would also be able to provide some really helpful insight. And something that the Uluru Statement talks about a lot is what does our future look like for our younger people? What legacy are we leaving for them? And all of the issues that are affecting our people now, our young people are going to have to deal with in the future. And so C is just about making sure that the voice is able to represent the views of all of our mob, including, you know, gender balance, young people, all of that stuff. D, it will be empowering, community-led, inclusive, respectful, and culturally informed. So this is just saying that there will be a requirement on the voice and the representatives that sit on the voice to consult and give platform to the voices of the people on the ground that they represent. It will be accountable and transparent, just like any other body or institution set up through the Constitution or Parliament or legislation. It will work alongside existing organisations and traditional structures. So the voice is about, you know, providing more platform, more emphasis on grassroots voices. It's not there to take over already existing structures or to do the work of already, you know, really great services, community controlled organisations. It's about pushing that up and doing better. It will not have a program delivery function. That one's pretty straightforward. And H, it will not have a veto power. So post-referendum, the ALP has committed to a process of consultation with community to hear what kind of model or influence and inform the voice design itself. And that includes, of course, the composition, how people will be elected, its powers, procedures, all of that stuff. So the referendum process, I don't want to go too much into detail about this. And if you're interested in it, I know when I first started this work, I knew kind of about the referendum process generally and about the double majority, but I didn't really understand how it worked in practice. So at the moment, we're up to stage 1, but we really haven't got past that. So the bill has been introduced, the referendum alteration bill has been introduced into Parliament, and it's currently going through a joint select committee, and there'll be a hearing on Monday in Orange. There's other hearings in Cairns, Canberra, Perth, I think, throughout the next couple of weeks, and submissions are open so that people can provide evidence or, you know, what they think, have a say about what they think about the proposed amendment. So it is quite technical, it is quite legal, but that's currently the stage we're in at the moment. So once that joint select committee releases its report on the 15th of May, we'll kind of move towards the next process of whether the bill will be passed or not. There might be some kind of argy-bargy there between the Liberal Party and the Labor Party around the wording. For us, it's really important that the wording remains as it is because it is the strong amendment. We do not want the executive government to be taken out of the amendment because it leaves open the possibility of the voice not being able to provide representations to the executive government. And I explained before why that's so important. So once that happens and the bill's passed, then we'll move to the pamphlet, and this will be the yes and no side. And this will be sent out to everybody that's enrolled to vote. You know, I think this will be a bit of a rough part of the process, especially for First Nations people. You know, we've seen a lot of the stuff in the media come out. Some of it's misinformation, some of it's blatantly disinformation. It's not factually or legally true at all. And a lot of it is muddying of the waters. The important thing is that we continue to have respectful dialogue and that we maintain that and look after ourselves, particularly as mob, I think. And as allies, I think it's important for, you know, non-Indigenous Australians to support us through that. Whatever our position is, it's really important that we maintain that respect and have those conversations respectfully and look after the health of our First Nations mob throughout that process, because it's going to be rough. And then we'll eventually get to go to referendum and vote yes or no. the double majority has always been a concern for people who said, well, why would you want to go and try to put a voice in the Constitution, because that requires a referendum and that requires a double majority. Out of, I think, 44 referendums, only 8 have been successful, but that wasn't an issue to the delegates at the regional dialogues. They said non-Indigenous Australia walked with us in 67 because you know, they believed it was the right thing to do. They believed in fairness, and we'll ask them to walk with us again. So the Uluru Statement was deliberately issued to the Australian people, not the government, not politicians. There's been previous bark petitions, statements that have been gifted to parliamentarians, to governments, and they've ended up on the walls of Parliament House behind glass. Nothing acted on, and the delegates said, we don't want that to happen again. We're actually going to ask the Australians to walk with us, and this will be about a people-led movement. It's not going to be about politicians. So they weren't concerned about this double majority, but obviously it is a high threshold to meet, and it requires a majority of all Australians to vote yes, and then it also requires a majority of people in a majority of states. So there has to be at least 4 states where there is a majority yes vote. And that's, I guess, what we're hoping for. I'm happy to take any questions, but if anyone is interested and wants to learn more, you can jump on ulurustatement.org. There's things like supporter kits, images and social tiles, videos and educational webinars that we've done over many, many years. Frequently asked questions and translations of the statement itself into both international languages and First Nations languages. There's also training and various tools on there as well. That's a little, you probably don't need to know that. You can also sign up to the newsletter if you want to keep up to date with what's happening, and follow us on social media if you want to keep up to date basically and learn more about the voice, the proposal, the referendum, and what you can do. So I'll end there. Happy to take any questions.
Fantastic, Bridget, and thank you so much for filling in details of history, process, just the detail around where we're currently at legally and otherwise in the political process towards referendum. So I'm sure there's heaps and heaps of questions out there. So I've got the chat box open and monitoring that. I'm going to ask people if they can raise hands, as has already happened. So thank you for that.
Yeah.
And we can go to hands, we can go to stuff in the chat. So
I'm happy for you to moderate it.
I will, yeah. And maybe Jen, if you can be another set of eyes on this chat as well. I'm going to go to some of the hands that I see already, and apologies if I don't get the order of when the hands went up correct. But Alan, you've got your hand up.
Thank you, Mark, and thank you, Bridget. That was an excellent presentation. To be honest, I have sort of been sitting on the fence with how I was going to vote with the referendum, and mainly because of the misinformation I think that's out there in the media. And the one thing I can't understand, having seen this and knowing that there's been so many years of consultation and so many working groups to get to this point, how our opposition leader can say there's not enough detail. So I find those sorts of comments a little bit disingenuous. I mean, I don't, you know, I'm not going to declare which party I vote for or support, but
yeah,
I think there's lots of detail, and you've provided a lot of insight into certainly not only the language but also the question that we're going to be asked. So for me, I've got sufficient detail from based on what you've told me. Have you presented this to the opposition leader? Maybe you could change his mind.
Yeah, look, we've had a few meetings, not me personally, but the team, and some other campaigns. So the Uluru Dialogue aren't part of the official Yes campaign. We kind of just stick to our own lane and do our own thing and focus on the education stuff. This has absolutely been presented to the opposition leader. Unfortunately, they've taken the position that they have. Hopefully we'll see some change in that, but ultimately we're not relying on bipartisanship. We're going to rely on the Australian people to have their say, and I guess we'll see that come out in the result.
But thank you, really good, really thoroughly, a lot of insight. Thank you very much.
Thank you. And as Bridget said, there's 10 reports worth of detail to throw oneself into. I spent a fair bit of time with the Langton Cama report yesterday, 272 pages, not unrelated to some of the detail around those design principles, etc. So thanks, Alan. I'll go to Barbara next. Barbara, are you still there with your hand up?
Yes, sorry, I was on mute. I unmute
Great.
myself now.
Great.
Now, I think the voice is quite good as it provides recognition for Indigenous Australian in the Constitution. I do believe that the First Nation, needs a greater say on the decision being made on their lives. My question is, what challenges are you encountering at the moment to promote the yes vote?
Knowing that Bridget's job is not to promote the yes vote so much as explain the Uluru statement through to the voice. Is that correct, Bridget? But nonetheless, what challenges do you see, I suppose?
Foremost.
Yeah, constitutionally, legally, otherwise?
I think the challenges are that as we move more through this process, politicians are getting more and more involved, and it's starting to become about them, particularly in the media. And that's why I think I took everybody through the process of where this actually comes from and why it was deliberately given to the Australian people, because we've had to take a step back here and say, well, actually, the Australians have to have a say on what they want us to be as a country. Do we want the birth certificate of Australia to completely deny the fact that there were people here, 60,000, possibly 80,000, according to the most recent carbon dating, since time immemorial? It doesn't recognise that in any way, shape or form, and we're one of the only countries that constitution doesn't recognise its First Peoples. I think we need to move past all of the being used as a political football, basically, and the media is emphasising that at the moment, and go back to the fact that we as Australians actually have the power to create a better future and create the nation that we want. And that there's overwhelming support for this in the community. There's a lot more work to be done around making sure that people are informed. But at the end of the day, the Australian people are going to have the power, and I think it's important that everybody understands that and feels a sense of responsibility to be informed about what this is, to have the conversations with their families, their networks about it. It's not about necessarily pushing one position or the other. It's just about opening it up and bringing the power back into everyday Australians to say, well, actually, we want our country to be this or whatever. We want our country and our birth certificate to truly represent who we are as a nation and celebrate that. And it currently doesn't. I didn't really answer your question, but I think the core of it is that the challenge is that it continuously gets taken back into politicians' hands, and it's really important that it's not. It's the Australian people who drive this.
And thanks, Bridget. I'll just note that on the news last night, we got some good footage of the flaws of the current hearings on the proposed amendments. So, constitutional lawyers like Professor Anne Toomey and others talking through the way in which the proposed amendment was put together. So wonderful example of law behind the news, law in the news, when you're actually getting direct feeds from those ongoing hearings. So thanks for that.
Yeah, I think as law students, it's I live streamed the hearing yesterday, and I would
That's
encourage
what the type
everyone
of
to go
nerd
back
work
and,
we want. Yes, that's right.
yeah, I'd encourage everybody to go back and watch it. It's available online. I'll find, maybe you can find the link and post it up. But it talks through all of the legal issues, and in the afternoon in particular, it was all of the constitutional experts such as Professor Ann Toomey, previous High Court judges, and really high up barristers. You know, two particular lawyers had very different views from the majority, but I think it's good to listen to those things and work through it and come to an understanding in yourself which one you align with, which one makes sense, which one doesn't.
Thank you.
Thanks, Barbara. Next hand up is Associate Professor Beat Harris. So one of our colleagues from Charles Sturt University with constitutional law and other backgrounds in law, thinking and writing a lot about constitutional recognition and other matters related to this. So thank you, Beat.
Hi, Mark. And unfortunately, only doctor, not associate professor. But anyway,
I've promoted you there, but there you go.
Yeah, thank you, Bridget, for that presentation. You know, I'm writing a book on Indigenous constitutional recognition at the moment and trying to see what would be needed if we were to implement the UNDRIP into the Australian Constitution. And I mean, the voice is just like the tip of the iceberg, but you've summarized two of my chapters very succinctly in your presentation. So there's just 2 points that, you know, I think really go into the heart of the educative function that's necessary during this referendum process. And the first is what I view, so this isn't so much a question as a sort of suggestion. The mischievous argument raised about, you know, judicial review, and I digress here to say that there seems to be an allergy on the part of particularly the conservative side of politics to the idea of judicial review. You know, the idea that government should be subject to the law and to the courts seems to be some sort of heresy. But leaving that aside, I think that there's been a deliberate misinformation about the role of the voice and the supposed consequence of an avalanche of litigation, because the text, of course, makes it quite clear that the voice may make representations. It's not up to the government to consult with the voice, and there is no need for the government to hold its hand in development of policy. The voice, like any other lobby group, if you like, would be able to make representations on a policy level, and one would hope that that would be taken on board, of course, but the government would be free, having looked at that, not to proceed with them. I think that, you know, the argument that's been presented is that it is to treat representations made by the voice, which is a communication from someone to the government, as being analogous to the government making a decision on a distinct person or group's rights, which are then subject to judicial review in the normal exercise of statutory power. So there's a world of difference, of course, as you and I know, and I'm sure many people here know who have a knowledge of the law, between a lobbyist making their position known and the governmental response to that not being justiciable, which is what we're talking about here, and the government exercising statutory power, which is subject to judicial review. And I think that the subtlety in that is going to be a big hurdle in trying to disabuse people of exactly why the voice doesn't create a mechanism for administrative review. And you know, it's really, really difficult, given the really low lack of civics education among the population as a whole, to communicate that. You know, it's unfortunately very easy to frighten people, but quite difficult to educate them. So that's one thing. The other is There's also, and I noticed this during the Republic referendum, where people would point to the experience of, 20 or 30 Commonwealth countries that successfully and very easily changed their head of state, and examples of Ireland as well, as to how the parliamentary system could carry on operating without the monarch as head of state, and the absolute refusal of opponents of reform to even engage with that. Now, I think, the examples of the Nordic countries where the Sami parliaments, which aren't really parliaments, but they're like Sami voices, have been able to operate and integrate into parliamentary systems, is also something that should be, referenced to explaining what the voice is and isn't.
Yeah, absolutely. And I think that's a key one there, is that, the regional dialogues itself, the terms of reference were clear that any proposal or reform had to respect democracy and had to respect parliamentary sovereignty. There's been a recent article, I think it only came out last night. There was some talk going around about how the Māori voice, which it really isn't, it's the tribunal, has kind of taken over the New Zealand government in terms of its decisions made around Māori. This is particularly a piece of disinformation, because you probably are aware, the Māori tribunal is a tribunal which hears grievances around the treaty.
Yeah.
It's not a voice at all. So there's all these things being thrown around, but the Sami Parliament in particular was a model that was talked about in the regional dialogues and discussed in terms of how it works, how it aligns with UNDRIP, all of those things. In terms of the justiciability, it's been an issue for us right from the beginning. People, and particularly professors in constitutional law, consistently bringing up this issue of justiciability. And I think yesterday's hearing said it quite clearly, from Professor Anne Toomey, Brett Walker, SC, and others, that it's a bit of a scare campaign. That, of course, there's absolutely the possibility that someone might pursue litigation around this, around a particular thing to do with the voice, but the likeliness of that is quite low. So I don't know, everyday Australians, when I'm talking to them on the ground, they're not concerned with this stuff. A lot of it's being discussed between academics and lawyers. So again, being taken away from the everyday people that this is really about. I think, of course, it's a valid concern to raise, but it's now gotten to the point where it's less about the legal effects of the amendment and in regards to justiciability, and it's more about the politics of it, in my opinion.
And look, there were just fantastic things as you referenced there, Professor Toomey and Brett Walker, saying that the inclusion of executive government in the proposed amendment, clause 2, is to avoid justiciability and increased litigation. But I suppose the counter view is being put by Professor Greg Craven and others.
Yep.
But then we've got former High Court judges disagreeing as well. We've got former High Court Justice Hayne versus Callanan in the media as well. So again, there's plenty of law behind the news for us to be engaging with here, and those live streams are where some of the real action is at too. Other questions? We've got nothing that I can see in the chat. Have you spotted anything there, Jed? Anyone else who wants to throw their hands up, please do so. We've got seven minutes, and plenty of issues still in everyone's minds, I'm sure. And please take the advantage of asking some questions now, at whatever level they are at. They don't have to be at the level of constitutional law or justiciability issues or anything else. They can be whatever you want to ask. As people are thinking, You did say at the start of your presentation, Bridget, that you might come back to the issue of how the voice as proposed, even in the amendment, may be a voice to state and territory governments. And I suppose my afternoon with the Langton Cama report yesterday was all about whether there would be local and regional voices, and we would be able to be a voice to all parliaments, Commonwealth, state and local. And, you know, the work that our elders in residence do with local governments, the work that many people do with state governments in community, made me think about the current proposal and who it speaks to, which governments it speaks to, and which levels of community it speaks to as well. Have you got thoughts on that?
Yeah, so just in terms of that, the reason I mentioned it was because the regional dialogues talked about, you know, in the future, the possibility for the federal voice, the national voice, set up under the Constitution, to have the ability to talk to state and territory governments where they request the advice. So that it wouldn't be proactive in that sense when it comes to state and territory governments. Of course, that would have to be set up in legislation that Parliament enact now, that it's not going to be included in the proposed amendment. So there might be the possibility there, and I think that will depend on what community think about whether that national voice would be beneficial for state and territory governments to talk to. Just in terms of the Langton Cama report, I just want to make it really clear that that was not a report that's terms of reference included a constitutionally enshrined voice. It was specifically a legislated voice, which makes a big difference. The voice that the regional dialogues talked about was a voice that is truly representative of regional communities, people on the ground. So it has to be diverse enough and big enough in its representation to be able to capture those voices, and that's really, really important. So the constitutionally enshrined voice that we're talking about at the moment, it is a national, it's a federal voice, so it will be able to advise on federal laws or matters relating to Aboriginal and Torres Strait Islander peoples. I think at the moment it's, you know, there's little pockets, of course, across the country where there's a really great relationship between local, you know, people, leaders, communities, and various organizations, bodies, local councils, where those voices are happening, right? And I talk to people every day and they go, oh, like, yeah, we're a part of this body and we advise to this particular, I don't know, organization. You know, for example, even the Commonwealth Bank now has its own Indigenous Advisory Committee, where decisions that are made that affect Aboriginal and Torres Strait Islander peoples, they're consulted on. The really important thing about the voice is that it has to be representative. It has to represent the regions, it has to represent their views. And I'm going a little bit off track here, but like, for example, you know, people talk about designated seats in Parliament. The problem I have with that is that they're still not representative of the views of our, you know, in our diversity. If we're only talking about 2 or 3 seats, how do they represent the views of all First Nations peoples in Australia? I'm absolutely not against designated seats in Parliament. I think they serve a particular purpose to an extent, but it still relies on that political system where the voice actually sits outside as an independent body, advises and makes representations to the Parliament and the executive. It creates that political power there that allows there to be accountability and transparency, which is really important. And it standardizes that process of allowing First Nations voices to have a say and to be heard where those matters affect us. I've gone a little bit off track there, but I think Barbara's got her hand up.
Yeah, thanks. And look, at plenty of things that spin off from that after the referendum. There's still a need for legislation for detail. The Langton Cama report said there's been a lot of talk about constitutional enshrinement as well, and we note that in our executive summary. Thanks so much. If there's no one else that wants to throw their hand up, Barbara, I'm happy to go to your hand again.
Sorry, I have to ask something because you mentioned about the elders in the voice body. Are they all in one with pushing for the same purpose, the same objective in providing advice for the government, because it's a big body as well, who will be composed of different, how do I say that, respectful, coming from different, do I
Yeah.
call it tribe or mob or something like that? So they're all in one when they're pushing or providing advice. What if the government say, no, we're not accepting that? What happens?
Yeah, absolutely. The voice is advisory in nature. So there will likely be a time when the government or the parliament rejects the advice or the representations of the voice. The important part of that, and this is where the political power comes into play, is that there will have to be a response. It will have to be transparent. The government will have to state why it's,
Why?
what it considered, why it didn't agree or why it did agree, and in relation to whatever the matter is. We don't currently have that relationship, and there's no accountability, there's no transparency. So, people might meet with politicians, advocate for a particular cause, provide insights, but there's no accountability there.
It will be a long process, isn't it?
Yeah, and just on the other part, in terms of the representatives of the voice, it's their role to actually provide the position of their constituents, right? So the people that voted them in as a representative. There's not going to be agreement between all of the voice members all the time either, and they'll have to work through that as a body. They're going to be, it'll be a legitimate institutional body that is there, and that comes through a referendum process. Australians say yes to this or no to this. If they say yes, then the Australians have spoken. They see that as a legitimate institutional body, and its core function is legitimate, and so it has to be taken seriously.
Seriously, yeah.
But the voice itself will have to deal with those internal differences as well, just like any other body organization.
Yes. Thank you for that.
Thanks so much for a rich session, Bridget, and there's a lot that we can be following still. I just want to thank you so much for being so hardworking in your role, but also hardworking on a Saturday for us. And
I don't get weekends much anymore.
No, but you look after yourself. And also, if you can give, if you're happy to, a copy of those PowerPoint slides, you let us know if you're happy with that. We've got the recording here. We had a wonderful discussion with our elders in residence as we were planning this session. Just to any of them that might still be on the line here, is there anything you quickly want to say before we swap over to our next presenter, either Werribee, Yana or Dinawan? Because we've already set up some work for Bridget and her organisation with the elders in residence going forward. So thanks so much for that being an outcome of this as well. If not, big thank you from us for your work today, and we look forward to seeing how our knowledge of this and the community's knowledge of this increases over time.
Thank you. Mandangu.
Okay, Mandangu to you. Thank you very much, Bridget.
Thank you.
So what I'm going to quickly do is I'm going to stop a recording.